All right. All right. Hello and welcome. Hello and welcome. Welcome. Thank you so much for being here. My name's Otis Landerholm. I'm really grateful to be here with you right here, right now, live. I'm recording this. It's the 15th of January of 2026. And I'm the host of the Empowered Immigrant Live and the Empowered Immigrant Podcast. And I'm really excited today, right here, right now, because we are adding a new addition to our series of podcasts and live sessions, and I'm calling it the Immigration Litigator. And so in the Immigration Litigator, we will explore and make sense out of what's going on in federal court, and really asking the question of how can we sue the Trump administration when they violate immigration laws. Okay? And so that's what we're doing right here, right now. This is our very first episode of that theme. And so welcome. Thank you so much for that. All right? So as you're tuning in, welcome. Thank you for being here. All right? Our topic that we're going to discuss on this podcast today is that there are no more arrests outside of courtrooms in Northern California. All right? And that's the topic. It's not, we'll explore whether or not that's accurate here today. All right? So welcome. Thank you so much for being here. Again, I am Otis Landerholm. I'm a certified specialist in immigration law. I'm also the founding attorney here at Landerholm Immigration, A.P.C, where we fight for your American dream. And I'm the host of the Empowered Immigrant Podcast, which is where we train, teach, inspire, and empower immigrants to make the most out of immigration laws and to make the most out of their lives. And today, welcome to our newest addition to our podcast, the Immigration Litigator, where we make sense out of what's going on in federal court, and we ask, how can we sue the Trump administration when they violate immigration laws and violate our rights? And really, we're looking at habeas, mandamus, APA claims, the Federal Tort Claims Act, and more. All right? Today, our theme is no more arrests outside courtrooms in Northern California, and we're talking about the case of A.P.C versus Nome. And my question for you is, do you know an immigrant who is detained by ICE right now? Because if so, they might need to sue about it. All right? They might need to sue about it, and a habeas lawsuit is a lawsuit against the government saying that their detention's illegal. And sometimes that can get people out of detention, okay? And so let me talk about this case, all right? And as I'm talking, if you have questions, please feel free to submit your questions. I'll do my best to answer them right here, right now, live. All right, so A.P.C versus Nome. This is a case, all right? And I want to share it with you. It's a case that is worth following. So Mrs. A.P.C is a woman who arrived to the United States from Peru. She arrived in April of 2023, and she explained to Border Patrol when she turned herself in at the border that she wanted to apply for asylum. All right, and they ultimately allowed her in the U.S., and they processed her, and they gave her a notice to appear in immigration court. They charged her with being deportable, but allowed her to come in so that she could apply for asylum. And she did that, all right? She filed her I-589. She attended all of her court hearings. She also has no criminal history anywhere in the world, all right? All was well in her court process. Then, on July 3rd of 2025, she went to her hearing in immigration court. And in court, the government attorney said, Your Honor, we're moving to dismiss this case, right? And they did it to put her into expedited removal proceedings. And this was common, all right? The Trump administration still does this in many parts of the country, all right? So the government moved to dismiss her case and put her into expedited removal proceedings, despite the fact in this case that she had more than 2 years in the U.S. on the date of that hearing. Okay? The immigration judge didn't grant the government's motion. Instead, they gave her time to submit a written response to the government's motion. But, even though it wasn't dismissed right then and there, but as she then got up and left the courtroom, 4 ICE agents, some wearing masks, all right, forcibly pulled her away from her family, who was there as well, and arrested her. Arrested her. Okay? Now, she was represented by an attorney. Her attorney was frustrated and angry by that arrest, and that same day, hours later, filed a habeas. Okay? Arguing that that arrest and that detention was illegal, was unlawful, violated the United States Constitution, violated the APA, the Administrative Procedures Act. Okay? That habeas petition argued that her arrest violated the Due Process Clause of the Fifth Amendment of the United States Constitution. It argued more things too. The attorneys also filed a temporary restraining order requesting immediate release from detention, arguing that the detention was unlawful. And the federal district judge granted that TRO on July 4th. She was detained on July 3rd. The federal district judge granted that TRO, temporary restraining order, on July 4th. Very fast moving, very cool. And she was ordered released. All right, now I don't know the specific date that she was released, but it might have been the 4th of July, right? Or it might have been the day after, very quickly happened. Okay? So how do due process arguments work? Let me explain that briefly. Okay? Remember, the Due Process Clause of the Fifth Amendment of the United States Constitution says that no person shall be deprived of life, liberty, or property without the due process of law. So the federal judge in this case explained that the government's depriving Miss Garo-Pinchey of her liberty without any process at all right, just detaining her for no reason following her court hearing, was a violation of the Constitution. All right? So that happened. Then it starts to get interesting. All right? I mean, it's already interesting. Then attorneys got together, all right, and they moved to join in this case. And they moved to turn this case into a class action. What's a class action mean? Who knows out there? You guys know this? All right, basically, it means that they filed amended pleadings, and they were seeking to turn the case into one case representing many, many people. That's what a class action is, right? So they filed a motion, all right, for class certification, and they filed amended pleadings, etc. And here's the class of people that they were seeking to be deemed a class. Okay? So the class, quote unquote, says this. It says, all non-citizens in the jurisdiction of ICE's San Francisco field office who, 1, entered or will enter, so it applies to people in the future too, entered or will enter the United States without inspection. All right? Think about if you know somebody in this situation. 1, entered or will enter without inspection. 2, have been or will be charged with inadmissibility, all right, under INA Section 212, and have been or will be released from DHS custody, all right. 3, are in removal proceedings, and 4, are not subject to any of the mandatory detention statutes, no serious criminal record, etc. Four pieces of the puzzle to be protected under this lawsuit. Okay? It says the putative subclass consists of all class members, quote, whose release from DHS custody was or will be on bond, conditional parole, or their own recognizance. All right, so we're talking about people who were detained briefly coming into the country, but then they were released. Can they be re-detained at their court hearing or outside of, or without any process, right? Without giving them a new bond hearing. All right, I see some questions coming in. Keep asking your questions. I love it. Keep asking your questions. I see them coming in. That's great. Welcome. Thanks everybody so much for being here. All right. So in this case, the lawyers argued, all right, that ICE's re-detention policy violates the law, violates the U.S. Constitution, violates the Administrative Procedures Act, the APA. The federal judge agreed and granted a motion to stay ICE's re-detention policy within San Francisco's area of responsibility, which is like San Francisco, Sacramento, Concord. It goes as far south, I think it goes as far south as Bakersfield, just north of Kern County. It includes Hawaii. It's a large area, all right, are governed by ICE's. It also includes some of the island Saipan, I believe, and Guam, right? Some of the islands in the Pacific. So that was granted on December 19th of 2025. All right, less than a month ago. All right, so what does this mean for you? What it means is that if you were released from immigration when you first entered, and if you have a court hearing coming up, that you should not be re-detained by ICE. And guess what, everybody? I was in court. I had a hearing in immigration court yesterday for husband and wife with their little baby girl infant on their lap. And they have less than 2 years in the U.S. They could have been arrested. And they were not arrested. All right? Quite possibly because of this order. And so, thank you to the litigators in this case. Those litigators have made a huge positive difference. And if you're an attorney and if you're watching this and if you're outside of San Francisco and the San Francisco area, hey, you might look at this case and you might consider filing a similar action in your district. All right? And if you're an immigrant and if you're fearing government detention, then you will have extra protection due to this case under habeas. And so talk with your attorney, and if you get detained, be ready to file that lawsuit and sue the government when we can, all right, to challenge their illegal behavior. And that's the point today, all right? That's the point. I hope that's useful. I hope it's helpful, all right? Now, that's all I got to say. And so I see some questions coming in. Let me know what your questions are, and I'll do my best to answer them. And, of course, there's a whole bunch of news happening with immigration. You've seen the expanded travel ban. 75 different countries are now added with a travel ban. I see some questions about that. I did a whole episode on the Empowered Immigrant Live earlier this morning about that. And so, yeah, that's big news. There's lots of different news. I just wanted to share this piece because it's important for anybody that's facing a hearing coming up, and it's important to understand what's going on in federal court. Okay? So let's see, some questions. Hey, Dr. Royalty, you say, can we work together? I do immigration psychological evaluations. Oh, man, please send me your contact information. We recommend psychological evaluations all the time. All right, so I really appreciate your saying that. Please send me your contact information. All right, let's see here. BMLT, how soon should we hear from a federal judge to decide on the travel ban? Yeah, that's a great question. It's not going to be immediate. All right, the travel ban, how soon should we hear? Good question. The lawsuit needs to get filed first, whether or not there's going to be an injunction. They are no longer granting injunctions at a national level, all right? And so it's got to be much more local. They're doing it in forms of class actions instead of permanent injunctions. And so, we might not hear for a while. There might not be a decision on the travel ban, right? That'll be tricky. I'm sure there's lots of lawyers that are working on it, but I don't know of any lawsuits that are being filed about it right now. All right, but as soon as I hear anything, I'll let you know. All right, JR, is it safe to get a work permit or a license while you're out of status? I mean, yes, I have clients who have licenses even while they're out of status. It depends on which state you're in. If you're in the state of California, the DMV is not supposed to share this data with ICE, and people can get under AB 60. You're allowed to get a driver's license in the state of California, irrespective of whether or not you have immigration status. Okay? And it's important that you do that if you drive, because you don't want to drive without a license. That is a crime, and so you want to get a license, right? Karen, are they questioning about your residence when coming into the U.S. from Tijuana? Yes, absolutely, every time. Okay, absolutely. They'll ask what your visa is, what your green card is, whether you're a citizen, like what documentation do you have when you're re-entering from Tijuana through the San Ysidro port of entry, or when you're entering the U.S. generally anywhere. Okay? Let's see, Voice of the Universe. You say, I got approved for a green card November 26, 2025. Congratulations. Got the approval letter, but the green card is not in until now. What do I do? Oh, yeah, that does seem like a long time to wait for the green card. I'm glad you got the approval letter. You certainly should carry your approval notice on you if you were ever to be stopped or something like that. Like, that is proof that you are a lawful permanent resident of the United States. But you should sorry, I lost my train of thought there. Yeah, carry the approval notice with you, and then you could file an I-90 request to replace the green card, saying that it was lost. Maybe it was lost in the mail. Maybe it went to a prior attorney's office. Those things do happen, unfortunately. And the way to get the replacement is on Form I-90. They take forever. And I would really, you might give it a few more weeks, although you've already given it since November. So, you might be stuck having to do an I-90. Okay? All right. Let's see, FAHD, you say, is a K1 also impacted by the new Trump administration order for the 75 countries? Please respond. Yes, I believe it is. All right. I do not know for sure, because I have not seen any nuance about, the 75 countries announcement is relatively recent, but I believe it's for all immigrant visas. The thing about a K1 visa, technically it's a non-immigrant visa, but you are using it to come in, get married, and then apply for an immigrant visa. And so I believe that it will be paused. All right? I believe it will. All right? And I don't know 100% for sure, but I believe it will. Okay? So please, stay tuned, and if there's better information about that, I'll be sure to include that in future episodes. Okay? Abby 96, you say, I came to the U.S. without landing. I came to the U.S. without landing. Married a U.S. citizen, and my I-130 is approved. What are my options? What do you mean by that? What does it mean you came to the U.S. without landing? You mean without being inspected and admitted? Or I'm not clear what that means. That's an interesting way to phrase it. But if you have an approved I-130, then either you adjust status if you're eligible, if you were inspected and admitted, or you pursue consular processing. For example, you apply for an I-601A waiver, if you're eligible for that waiver, and you move forward with the National Visa Center and then scheduling a consular appointment in your consulate. Now, it will depend on whether or not you're from one of the 75 countries that have been banned from going through the immigrant visa process, right? That will cause a pause for you. But yeah, the best advice there is have an attorney, talk it through with an attorney, have an attorney guide you as to whether or not you're eligible for adjustment of status or whether you need to go through consular processing and then take those steps. All right? Very good. Let's see, Devanesh. And anybody that's tuning in right now, welcome. Thank you so much for being here. Again, my name is Otis Landerholm. I'm an immigration attorney and certified specialist in immigration law. And I am the founding attorney here at Landerholm Immigration A.P.C, where we fight for your American dream. I'm grateful to be here with you right here, right now, live. It's the 15th of January of 2026, and thank you so much for being here. Okay? So I'm talking about federal court litigation in the immigration context, but right now I'm answering questions. So thank you, everyone who's asking your questions. It's an honor to be here with you today. Okay? So Devanesh, you have asked, my wife has an interview in one of the 75 countries that's been paused. Will trying to attend the interview before the 21st help? No. All right. My belief is that no, that it's going to be paused. Okay. And so if I'm wrong about that, then hey, go for it. Good luck. But I believe that it will not help. Okay. Nancy Phil, you say my son is joining the Army, U.S. citizen, 17 years old. I have overstayed my visa. Can I apply for anything? Well, so you have a U.S. citizen son who is joining the Army. He's 17, and you entered with a visa, but you overstayed it. So here's what I would normally, best step first is to do a consultation and get you good legal advice, all right, and figure out whether or not there's something that we could do sooner. But if there's nothing else to do, then my response would be, oh, well, your son's 17. In 4 years, your son will be 21. Once your U.S. citizen son turns 21, they can file a petition for you. You can adjust status since you entered with a visa. All right? And so in 4 years, you'll have a great case, and you might be eligible for something else today, and the thing to do there would be to, talk to an attorney, see if you're eligible for something else here today, and if not, hey, at least you are eligible through your son, it sounds like, in just a few years. Okay? Let's see. Came to the U.S. Yeah, okay, got that. JR, you say, is it safe to get a permit or a license while you're out of status? Oh, I answered that already. Yes, it is. I do recommend it. People's Victory 2, the travel ban affects the immediate family of asylum holders who are still abroad, question mark. Well, so asylees are in a different context. Like if you were to do an I-730 to bring an asylee, a derivative asylee into the United States, or a spouse or child of an asylum holder into the United States, whether or not that would be prevented by the travel ban, I think not. Okay, I think not. That would require a bit more research than I can do right here, right now. But if we did a consultation, right, we could look into that detail with you. I think that you could petition for them as an asylee, as long as you're doing it within 2 years of your grant of asylum, etc. Like there's rules for the I-730. But if you aren't eligible to do that, and now you become a permanent resident through your asylum and petition on the I-130, then I think it would be affected by the travel ban. Okay, so AJ, you say, my citizen husband passed away last month. How will that affect my status? Now I want to apply, but I'm scared. Man, I'm sorry to hear that. I am sorry to hear that. Spouses passing away is horrible. Okay. I was in a consultation just maybe 2 days ago with a woman from Thailand who entered and then got married, and then her husband, they lived together for 2 years, and they just hadn't gotten the paperwork together, but they were planning on it, right? And her husband goes in for a routine surgery and dies. All right, and now she's really scared, right? So I'm saying that, AJ, to tell you, like, you're not alone actually in your scenario. It's a horrible situation to be in, very scary. And there is something on the I-360, there is a widow or widower petition. All right, if you're married to a U.S. citizen, if you file it within 2 years of the date of death of the would-be petitioner, you can file a petition after the death of a spouse. Okay? And so feel free to contact my office. We could do a consultation. We could really get to the bottom of how to do that in your situation, but there are options. Okay? And so, so that's how that is. Karen, I see your question here. You say, but do they ask how you got it or do further questions? They certainly can, right? So when you're coming in at the border, if everything looks good to the initial officer, they'll stamp your passport and allow you in. But if there's any additional questions there, they can send a person to secondary inspection. And in secondary, they'll ask all these questions. How did you get your visa? How did you get your citizenship? How did you get your whatever? Like, typically, they're not scrutinizing U.S. citizenship right there at the border. All right? Typically, they're not. But they certainly are, they often do scrutinize your visa or your residence status, your green card, right? They do that all the time. If you have a green card, for example, but you've been out of the country for a long time, yeah, they can take away your green card. All right, and they can allow you in and say, hey, if you want your green card, you got to show up to court and fight about it because you've been out of the country too long. All right, they can do that. All right, and if they do that, feel free to contact my office or contact your lawyer because you're going to need to fight about it. Okay, so let's see, 3.16 with the dollar sign. Good to see you here. Let's see, USCIS acknowledged my I-130 since July of 2025. You're still waiting on a response. Can you say if there is a delay? Yeah, that's not enough time of a delay to say it's anything abnormal, right? Do you have receipt notices? Do you have proof that your application was received properly? If so, it's normal that July to right now is what, 6.5 months, right? And so, I-130s often will take a year, right? Sometimes less, I know, but they often will take a year, sometimes even longer than that. And so right now, I would say it's within current processing times. You got nothing to worry about. Okay? Mohammed Aden 554. All right? You say, is there any risk for someone who was granted asylum and filed their green card and they're still waiting? I mean, good question. I'm not going to say there's no risk, but it's very low, right? It sounds like you've done everything well. You won your asylum claim. That's the hard part, okay? And now you're filing for a green card. As long as you don't have any arrests, as long as you haven't violated the terms of your asylum status at all, you'll probably win your green card as long as it was done properly, etc., right? The hardest part is winning asylum. After that, it's simpler to win a green card, and after that, as long as everything's clean and good, after that it's typically even most simple to win U.S. citizenship if you go through that process. The hardest part is winning asylum, all right? Asylum is very difficult, all right, especially right now. And so you should be okay, okay? Absent, if you've ever had any arrests, then talk it through with a lawyer. If you want help to make sure your green card application was done properly, talk that through with a lawyer. If you don't have a lawyer, feel free to contact my office. We're here to help. We'd love to help. Okay? All right. Let's see. Ahmadi. Ahmadi. Is there an interview for the I-751 and how long is it taking? Thanks. That's a great question. Ahmadi, thank you for asking that. All right, so, in the past, some I-751s would have interviews, some I-751s would not have interviews. All right? Right now, err on the side of you're going to have an interview. Right? Err on the side of yes, you're going to have an interview. Okay? And how long does it take? I don't have the current processing times for I-751s just handy right now. All right? I would say approximately 2 years, give or take, right? That's my best estimate based on what I believe them to be. Okay. Let's see. And I'll tell you worst case scenarios. Like I have had cases that were I-751s that took 7 years. All right, and took filing mandamus actions and took, doing inquiries and even congressional inquiries to try to get them back on track. Sometimes they go into a black hole, but majority, I would say about 2 years. Okay, so Coach Guile Light, Arizona. I'm sorry if I didn't say your name quite right. I am in Juarez now doing that process. Okay, cool. The consular process? Great. That's awesome. That's great. Thank you for letting us know and best of luck as you go through that process. All right. Let's see. Hector Montero. My sons are American citizens. They're 11 years old. I'm Mexican. They can help me to obtain U.S. citizenship. Okay, great. So if they're 11, the way it works is once a child turns 21, they're allowed to petition for their parents. Now, whether or not the parents can use that petition depends on a lot of different things. All right? Are you in the United States or are you outside the U.S.? Have you ever committed any crime anywhere in the world? Have you ever used, possessed, cultivated, sold, had anything to do with any illegal drug, narcotic, including marijuana? Right? Have you ever been a member of any group that supported or assisted or otherwise participated in any bad thing, killing, harm, weapons, sales of drugs, trafficking, anything like that, terrorism of any type, right? All the inadmissibility questions, because when you're the parent of a U.S. citizen child who turns 21, right, there's 3 requirements to get a green card, all right? The first is, if you're in the U.S., rather. The first is you have to have been inspected and admitted or paroled into the United States. The second is you have to be the parent, the approved parent of a United States citizen child who has turned 21. And the third is you have to be, quote unquote, admissible. All right, and if you have those 3 things, you can adjust status. If you are outside the U.S., then you really just need to be the parent of an approved beneficiary or of an approved petitioner, and you have to be admissible. And so talk it through with a lawyer, and we can help you through that process. All right, and you might be eligible for things sooner than that. All right, I realize that's 10 years away for 11-year-old children, and so if you're eligible for something else sooner, you would want to talk it through with an immigration lawyer. Feel free to give us a call. Right. So M, you ask, I'm glad we're getting so many questions. This is great. My throat is starting to feel scratchy, and I've got 7 minutes left, so I'm just being clear, all right? So J, M, you ask, I came in as a minor now, and I've overstayed my visa. I want to marry a U.S. citizen. What's the process? Cool. Or someone. You're not necessarily saying you. Okay. So same thing, right? As long as you were inspected and admitted or paroled, entered on a visa, great. Even though you overstayed it, okay, got that, all right. And as long as you're in a good faith, bona fide relationship with a U.S. citizen spouse, and as long as you're admissible, do a consult with a lawyer to go through all the inadmissibility questions, then congratulations, you're eligible to adjust status. Okay? All right, Jay, you ask, how much do you charge for Form I-130 for a family of 3? Okay, so in our firm, we start with a consult, all right? So feel free to call our office, schedule a consult, and let's do it, all right? And we need to know a lot more details before we recommend filing on I-130 for a family of 3, or before we recommend any service, and before we decide whether or not we're going to take the case. All right, so let's start with a consult, and then we can give you pricing and figure all that out. If you're like, no, I just want price, our firm's not the right firm for you. All right, we go step by step, and we do it the right way. For us, it's more important to win and to do it well and to do it professionally than to go cheap. Okay? I should just declare that. I should declare that from the mountaintop. Right now, it is more important to do your case well than to do your case cheaply. All right? And that's true for everybody. That's like the best advice I can give you right now. All right? Angie, how long are MPIP cases taking? They are so frustrating. They are so frustrating. All right, Angie, thank you for asking that question. There are MPIP, military parole in place. The processing times are not published. They depend and vary depending on which field office your case was sent to. They sometimes go into dark rabbit holes that get no response from them. They can be very, very frustrating. We have done them, we have won them, but sometimes they take up to 2-3 years, and sometimes we get zero information from the government as we're waiting. And so, yes, they can be very frustrating. Okay, Mohammed Adan. Oh, I already answered your question. All right, thank you. Brazuca, are LPRs affected by the 75 countries travel ban? No. All right, it's for the 75 country travel ban is for people applying for immigrant visas. All right, if you already have an immigrant visa, my understanding at least, if you already have an immigrant visa, you are not subject to the new 75 country travel ban that was just announced. Okay, thank you for asking that. WIFRI material. Let's see, I got 1, 2, 3, 4, 5 questions, and then I'm going to wrap up. All right. So WIFRI material 43. How does this new pause affect my I-601A travel consular processing from Guatemala? Good question. Your I-601A should still be adjudicatable. All right, adjudicable. You should still be able to get a response from USCIS on your I-601A, but you will not be scheduled for your interview in Guatemala until this travel ban is lifted or fixed or gone away. Okay, that's my understanding is that's how it will affect that process for you. Okay, and this is very, very new, and the government has not given very clear information even to us immigration lawyers yet. As we get more information about how this latest travel ban will go into effect, I will continue to be announcing it, all right? So if this content matters to you, if you want to know more, please subscribe to our channel. Please like and thumbs up and heart our channel and our content, and that'll increase the likelihood that you stay in touch and see additional content like this once we know more information, all right? Of course, the best way to know information is to go to our YouTube channel, hit the subscribe button, and hit the notifications bell. Then you will really receive a notification every time we upload an additional video. Okay? Alish AQ177, you say, I'm scared of ICE because it's a pending asylum application 10 years. Wow. And you're 21 years old. Yeah. I mean, it sounds like you've done it right. Okay? You've got an asylum application pending. It's the government's issue and the government's fault, I'll put it that way, that they haven't adjudicated your case in 10 years. And shame on them, right, for not adjudicating your case for 10 years. And, you know, you could sue about it. You could file a mandamus. I'd be happy to help you with that. Of course, all asylum applications right now are paused throughout the U.S. Anyway, it sounds like you've done it correctly. All right. Now you have every right still to be scared of ICE. ICE is violating people's rights and arresting people sometimes with disregard of the laws. All right. But you've done it right, and you have the right to be heard on asylum even if you were arrested, right? Like just say, I'm afraid for my life to return to my country. I have filed for asylum. Give me the right to fight my case. All right, and I hope you're working with a lawyer. If you were ever actually arrested, call your lawyer immediately. You should file a habeas. Okay. Vern's British. You say, my interview is next Friday. Will the new immigration law affect me? Where are you from? All right. And is your interview in the U.S. or is it overseas? I would say feel free to give us a call. We could do a consultation. We could see how this new law will affect you. All right, Tati Lomba. My green card expires in July. You mentioned to me you could get an extension. Is that correct? The request for an extension should be done this month. Correct, yeah. A green card extension needs to be done 6 months before the green card expires. Okay? And Tati Lomba, you ask, is Mexico one of the visa, one of those countries that were on the visa ban or the travel ban? No, Mexico is not, at least not on today's date, right? The full 75 country list, you could feel free to do a Google search about it. Brazil is on it, Guatemala is on it, Nigeria, Russia, Iran, Pakistan. There's lots of countries, all right, are on this 75 country list. Nicaragua, Colombia, Cuba, right? There's lots of countries that are on this list, and so you got to be aware of it, okay? Lilac Conversations. Hi, does your office help with RFEs? Yes. 1,000% yes, we do. All right, we'd be happy to help you if you have a RFE that you need help with. All right. Kathy G. Hi, me and my American citizen husband applied for an I-130 17 months ago. How much longer will it take? Yeah, that's an interesting one. All right, so 17 months ago, that probably is outside of normal processing times, and you might be ready to start doing inquiries and even think about a mandamus action to push that forward, and so yeah, I'd be curious to look at your case and review it and see if there's any reason that we could see that might have caused the delay. Okay. So Coach Gailet, Arizona, good to see you again here. You say, have you heard of anyone being denied a visa for marijuana use if there was no criminal charges? The answer is yes, I've heard of that. All right, yes, I've seen it. Okay, and I've also pushed back on cases like that. I have whole videos about the topic of marijuana use. All right, like anyway, yeah, that's a bigger conversation for another day. But yes, there are ways to push back about it. All right, in certain instances, like for example, government. I have the right to be presumed innocent. Under the U.S. Constitution, I have the right to be presumed innocent until proven guilty of a crime that I've been accused of. So it's like if I haven't been found guilty of a crime related to marijuana, then I have the right to be presumed innocent of it. All right? How does that play out in an immigration case, right? I've argued and won a case on that specific argument. All right? My client had the right to be presumed innocent, so you should not have denied their green card based on based on a possible use, right, of some substance that they don't even, wasn't documented. There was no arrest found. There was no this is just like it's almost like speculative that they consumed the substance that was brought up in that case. All right. So, all right, I'm out of time, folks. Thank you all so much for being here. Jose, you say I got a case dismissed, got out on voluntary departure. I have no bars, have 2 kids and a common law wife. How do I get back? Thank you. All right. Well. I'm glad that you had your case dismissed. I'm glad that you had voluntary departure. You might still have bars, though, right? It depends on how much unlawful presence you had in the U.S. If you had more than a year of unlawful presence when you left, then you triggered a 10-year bar. There are waivers of the 10-year bar. We'd have to do a consult, is the bottom line. All right? Kelton Shields, when is a writ of mandamus appropriate? 6 months after the interview. Marriage AOS. Yeah, great question. If it's on the I-485, I believe 6 months after an interview, you should be okay to file a writ of mandamus. And I'll do a whole episode on mandamus cases very, very soon on this exact podcast. So that's a perfect segue. Everyone, thank you all so much for being here. I hope this was useful. I hope it was helpful. All right. If it was, please give us a thumbs up. Please give us a heart. Please subscribe to our channel, especially our channel in YouTube. All right. When you subscribe in YouTube, if you could also hit that notifications bell, it allows our platform to perform better, and it gives you a notification whenever we upload additional videos with news, with updates, with things that are going on and that are relevant for your immigration case. That's all I got for today. Thank you all so much for being here. I really appreciate each and every one of you. My name is Otis Landerholm. I'm the founding attorney here at Landerholm Immigration, A.P.C, where we fight for your American dream. Hey, if you are an immigrant and if you have a question or a case and you're wanting to schedule a consult, you should be able to find the phone number in the platform that you're on. All right? It should be like a description of the video. All right? And if it's not there, just go to our website, Landerholm Immigration. You'll find our phone number. Just give us a call. That is the simplest way to put yourself in contact with our office and with our team. We're here to help. We'd love to help. Okay? Thank you all so much. Make it a great day, and we'll see you next time. All right? We'll see you next time on either our episode of the Empowered Immigrant Live or this same time, 1 p.m. every Thursday, I'm going to start doing episodes of the Immigration Litigator, where we talk about federal court cases. Thank you all so much for being here. Make it a great day, everyone. I appreciate you. Take care. Bye-bye.